Welcome to everybody. I want to say hello to our speakers, Natalia and Zoe and Grant. And I don't think Eduardo's with us yet, but I'm sure he'll join us soon. And I'd like, before we start, so I'm Lisa Mead. I'm with the Earth Law Alliance and also Earth Thrive. And Zoe from Earth Thrive has been helping me to put these webinars together, which Consensus Law are kindly hosting. And I just wanted to hand over to Fidan Namazova to say a few words from Consensus Law.
Sorry, I'm joining with my PC as well. Thanks, Lisa. First of all, representing Consensus Law magazine, I want to welcome both participants and speakers, especially our dear moderator, Lisa, and for her massive contribution in organizing this event and partner organizations which are working for a better world. It is so meaningful how that many people are interested in the rights related to ecology and nature, and I really believe that Ecolo webinar series will enable us to exchange our knowledge and practice regarding this vital field of law, which not only matters for today, but also for tomorrow. And I'm happy to declare that as Consensus Law magazine, we will be doing more events, webinars in future regarding ecology law and other fields of law. So I don't want to take your time. Thanks for participation, and please don't hesitate to ask your questions. Let's make this webinar as interactive as possible. Thank you once again.
Thank you, Fidan. So yeah, my involvement in this area of law is it's been for about 8 years, and I have to say, when I first got involved in this area and rights of nature had come through in the Ecuadorian constitution and in a national law in Bolivia, at that point I was still a bit skeptical about whether it would take hold in a meaningful way in other countries. But I'm happy to say that it has done, and it is doing. And one of the reasons for holding this webinar now is because we've had exciting news in Europe recently with the recognition of the rights of the Mar Menor in Spain, which Eduardo will talk more about. But first, I would like to introduce Natalia Greene, who I've known for a number of years now, and she is with the Secretariat of the Global Alliance for the Rights of Nature. But she's been very, very closely involved with a number of the cases in South America, just with the whole evolution of this area of law, really. So I'm really delighted that she's able to be here and talk to us a little bit more about the underpinnings of rights of nature, what it means, and how it's evolved and is still evolving in her part of the world. So over to you, Natty.
Thank you, Lisa. I'm very, very happy to see many friends here. And thank you to Consensus Law magazine. I think it's very important to start working and having more attention on this, especially with media. So I'm going to go ahead and start and share my screen. If you can just tell me if you can see it, I can start. Perfect. So thank you so much. As Lisa was saying, I'm with the Global Alliance for the Rights of Nature. I'm also with the International Rights of Nature Tribunal. And in Ecuador, my home country, I'm the Vice President of CEDENMA, that is the National Coordinating Entity for Environmental NGOs. So I want to start by Ecuador because I think that a lot of this movement was raised or at least pushed by the promotion that Ecuador gave by recognizing the rights of nature in its constitution. And I just want to give you all a little bit of background. Ecuador is a really biodiverse country. As you can see, this is the biodiversity index of the country, and a lot of its biodiversity is still focused in the Amazon. So it's a really unique and biodiverse country. I always feel and I welcome people when they come, saying that Ecuador is a place where miracles happen, and one of them was the rights of nature for sure. But unfortunately, many of our authorities have viewed and still view Ecuador as this country, a country pretty much traced with like oil blocks and mining concessions and hydroelectric plants. And Ecuador is a country that has been living off nature for a very long time. Fortunately, we have here a map of indigenous nations that live in the Amazon. And if you compare this map with a previous map, you'll see that a lot of the biodiversity in Ecuador is mainly still in stewardship of indigenous people. So what happened in 2008? Ecuador changed its constitution in 2008. This was after a process of a long process of political instability of Ecuador, a decade of changing many presidents, of changing our currency to dollars, of a lot of instability. And we were aiming to look for a new country. So this constitution says, let's leave the past let's leave the past behind. And we started this new constitution process with exercise of what's the country we dream of. So one of the issues that I was fortunate to be involved with was with the political lobbying to involve and to include the rights of nature. And after a lot of conversation, and that can be a whole webinar itself, like how it came into being, but especially after recognizing that our constitution was a very wide focused document, and that we needed to make it more democratic. In Ecuador, we have a large indigenous population, not as much as many people think. It's mostly like 10 or 14% maximum. But we do have like a lot of like culture of indigenous worldview. We were able to include this idea that nature is our mother, and we were able to include these rights: the rights to existence, the right to regeneration, the rights for the maintenance of natural cycles, structures, functions, evolutionary processes, and the right to integral regeneration. So it was actually in April 10th that these articles of Chapter 7 were included in our Constitution. This first one is the one that I just read, the nature of Pachamama. This is very interesting because we're comparing and making a synonymous of nature and Pachamama. But for indigenous people, Pachamama includes much more than what we consider nature. It includes the cosmos, it includes much more. And it, of course, recognizes that we need to respect its existence, regeneration, functions, and evolutionary processes. I have also highlighted here in Article 72 the right of nature to be restored. You can access to these articles, and I can share the presentation as well, so you can read it with more attention. But I wanted to focus also on the articles that we mostly use now, that 14 years later, we are using these articles to litigate in the name of nature, in favor of nature, especially using two provisions. First, let me go back to Article 71, where it says that all persons, communities, peoples, and nations can call upon public authorities to enforce the rights of nature. So we can all really guarantee the rights of nature. And one of the articles that we use the most in the Ecuadorian legislation is this Article 73, where the state shall apply preventive and restrictive measures on activities that might lead to the extinction of species, the destruction of ecosystems, and the permanent alteration of natural cycles. This is quite interesting because, as you can imagine, being such a biodiverse country, we have many species that can easily go extinct and are going extinct because of all the activities related especially to extractivism, to oil, to mining. And this is an article that we use a lot. And finally, Article 74 is focused more on the environmental services, where those services should not be a subject of appropriation, which is quite a different aspect on how people are trading ecosystem services, especially now that the COP is happening in Egypt. This is quite a hot topic that actually the government here in Ecuador is trying to change. But I can talk about that later. I wanted to show you that as Ecuador, we did inspire a very big growing movement. It did start in 72 with the article of Christopher Stone, Show Trees Have Standings, but this has grown a lot. It has grown with different cases, different countries, different ordinances, different case studies. And I'm going to talk a little bit about how this movement has grown much more. But I want to focus a lot on the year 2010, where there was this conference that was held in Bolivia. I was in Copenhagen the year before, and instead of Copenhagen, we called it a Copenhagen, thinking that something was going to occur, and nothing did occur, as it hasn't occurred in many of the COPs. And right after that, Bolivia organized this really big conference. And the result of this conference was the Universal Declaration for the Rights of Mother Earth. This also led to that same year to the second resolution of harmony with nature that was adopted by the UN General Assembly. So what does this declaration say? It says that Mother Earth is a living being. It says that it's unique, indivisible, a self-regulating community of interrelated beings. It says that each being is defined by its relationship as an integral part of Mother Earth, that the inherent rights of nature are inalienable in the rights of, hold on, that I can see everything here. In that they arise from the same source of existence, that Mother Earth and all beings are entitled to all the inherent rights recognized in the declaration, that just as human beings have human rights, other beings have rights which also are specific to their species, and that that the rights of each being are limited by the rights of other beings, and any conflict between their rights must be resolved in a way that maintains the integrity, balance, and health of Mother Earth. This article is quite important. We use it a lot in the Rights of Nature tribunals that I'm going to mention briefly. But also I wanted to mention Article 2, that what are the inherent rights of Mother Earth, where it says that nature has the following rights: the right to life, the right to exist, to be respected, to regenerate its biocapacity and vital cycles, to maintain its identity and integrity, the right to water, the right to clean air, to integral health, to be free from contamination and pollution, to not have its genetic structure modified, to have a prompt restoration, to each being has the right to a place, and they play its role in Mother Earth, and every being has a right of well-being and life free from torture and cruel treatment by human beings. So I really advise you to revise this document. This document was presented to the United Nations. Unfortunately, this document has not been adopted. There's a whole movement of rising signatures to keep on promoting the inclusion of this document. However, we do use it as a legal jurisprudence, especially for our tribunals, because it was legitimated and voted in favor by 33,000 people in that gathering in Cochabamba, Bolivia. Right after that same year, we created GARN. We came back to Ecuador and realized that we weren't the only ones crazy in Ecuador. There were many other crazy people in the world. And that's why we created GARN, the Global Alliance for the Rights of Nature, that now has grown into a bigger movement. We have many hubs that are regional, like Latin America, Europe, and Africa, and also some hubs that are thematic, like the academic, the youth hub, the legal hub, and the Indigenous Council. We even have a Réseau Francophone that is part of the European hub. So this has grown with 37 countries that have adopted the rights of nature. Actually, 42 countries have air jurisprudence cases. I invite you to look at this AG monitor, air jurisprudence monitor, that we already have in our website, garn.org, to see how this amazing idea of the rights of nature has really filled the world with what I call an acupuncture to the world, because all of these cases are happening, and it's a movement that is growing all around the world. I'll show you some very quick cases, because I want to respect the time. And one of them is the Wanganui River, where the Maori were able to reclaim the Wanganui River and recognize it as a legal persona. This is more of a case of stewardship of nature. The Amazon, for example, and the Atrato River in Colombia have also been recognized as subjects of rights. We have all the rivers of Bangladesh that are subject of rights. Lake Erie as well in 2019 adopted a Lake Erie Bill of Rights. And 2021, we have Oaxaca, Mexico, with collective as a collective entity subject of rights, and Uganda as well. And I'm going to leave the big cereza del pastel, the big cherry of the cake, to Eduardo to talk about Spain. But I want to briefly talk that we have really organized these international rights of nature tribunals to promote the idea that rights of nature should be included, and the fact that countries don't recognize it yet is a fault of the countries, and hence we are doing this subsidiary role of organizing rights of nature tribunals. We've organized them in Quito, in Lima, in Bonn, in Paris, in Chile, in Europe. We did this during the pandemic online. Lisa was our beautiful judge for this tribunal. We organized this in Glasgow as well. Lisa was there too, about the false solutions to climate change and the Amazon as a threatened living entity. And this has allowed us to really normalize the concept of the rights of nature. So going back to Ecuador to start closing my talk, we have been able to recognize the rights of nature and really go to the protection of these rights. We're litigating, for example, in the case of INTAG, for these two frogs. I'll show you their beautiful pictures. These two frogs were considered extinct, and they reappeared in a place that is affected by a mining concession. And we're litigating in court on favor of these frogs and their right to exist, because they are on the verge of extinction. And by protecting them, we're protecting a series of also other species that live in this same territory. The cases in Ecuador are on vanguard. The Constitutional Court has really selected some amazing cases. One of them is the case of Los Cedros, that in 2021, the Constitutional Court enforced the rights of nature to safeguard the Los Cedros protected forest and declared that mining activities were prohibited in this territory. You can find more, well, if you speak Spanish, in our legal observatory for the rights of nature in Spanish in this website right here. But this is an amazing case that I really advise you to talk and to read if you haven't read it yet, because it really demonstrates that how biodiversity is displaced and how activities that threaten the rights of nature must not be carried out in ecosystems so fragile as Los Cedros. We have cases like the gas flaring cases. And what's the next phase? Really to enforce the law and the verdicts and to start a transition towards post-extractivism, because of course, not all of nature is guaranteed only with the constitutional provisions. So we still need to systematize, disseminate, and educate on the achievements, especially of to the judges that are taking on these cases. So to finish up, here are my contacts. You can find a lot of more information of what I briefly shared today in our GARN website, on the Rights of Nature Tribunal website, and in this Legal Observatory website about Ecuador, if you're more interested of what's going on in Ecuador. So Lisa, I hope I didn't overpass my minutes here. And
no, not at all. That was great. Thank you, Natty. I think I forgot to say at the beginning, we'll save questions for the end. So we have 3 more speakers. So if you can maybe put your questions as we go into the chat, and I will try and take notes, and then we can address them after everybody's spoken. But now I would like to invite Eduardo Salazar, who's with us now, to speak on specifically on the Mar Menor saltwater lagoon case, which I won't say any more than that. He will tell you all about it. Eduardo is an environmental lawyer from Spain, and he's been very closely involved with Lady Teresa, who we will also talk about, I'm sure, in how this whole evolution of the saltwater lagoon being recognized in the Spanish Senate, so the parliament in Spain to have rights, and then how that is going to, or what happens next, basically. So over to you, Eduardo.
Hello to everyone, and thanks, Lisa, for inviting me. Thanks to Consensus Law for organizing the meeting. I hope you can hear me. Can you hear me?
Yeah.
Okay. I want to share my screen. I cannot share the screen because
Fidan maybe has to allow you to share.
Just 1 minute, please.
Yes. Perfect. No, I cannot. I can sing a song during the. But maybe it's better I want to talk about Mar Menor case as a long-term case. I mean, with perspective. I hope I can use now. Perfect. Thank you very much. This is the Mar Menor in the background. This is a very beautiful lagoon at the southeast of Spain. you can see the sunset behind me in the picture of myself, because this is a picture of Mar Menor. And you see, this is the Mar Menor. It's situated at the southeast of Spain. I think you know, all of you know where Spain is, but maybe you don't know where the Mar Menor is. It's just at the Mediterranean coast. It's a coastal lagoon, just like this. And it's a very beautiful landscape. Not only landscape, it's a very powerful ecosystem who has a specific biodiversity because of it's separate from the Mediterranean. You have here the different characteristics of Mar Menor, which is a complex ecosystem. It's not only what you see, because what we got in the law, it's not only the Mar Menor, but the basin. The basin are 120,000 hectares. No, 120,000 hectares. I mean, it's a very big goal, what we did in the parliament. The question with Mar Menor is that we the Spaniards, the Spanish people, we used to protect the Mar Menor with the conventional environmental law. Conventional environmental law is the law who was before rights of nature came to us, because conventional environmental law is anthropocentric. What means that? That we take care of nature as a nature is an object. And what we want to express from Murcia to the world, to Europe, to Spain, to Europe, to the world, is that the nature, Mar Menor, is not an object, it's not a natural resource, it's more than this, it's a subject. These are the different protections that the Mar Menor had, which is a Ramsar Convention, because it's a very beautiful, very important wetland, area of a special interest in the Mediterranean Sea, because of in relation with Barcelona Convention. It is Natura 2000. It is Natura 2000 European Biodiversity Network. So it must be protected with the highest protections. And in the regional law, it is a regional park, not completely, because it got this picture is not regional park. This is in the middle of the Mar Menor, and you can see that it cannot be a regional park because it's so crowded from buildings that the Mar Menor was partially protected as a regional park. This picture is not so easy for me to explain, because it was just one day before my birthday in 2019. It was a very bad present for me. It was a very bad present for anyone who loves Mar Menor, because we could see how tons of fishes and other animals went to the shore in order to look for oxygen, and they died in this search. Not only the fishes and the animals were so, we lost 85% of marine prairies, which is very, 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 very significant for the case. We have called the case of Mar Menor as an ecocide, because this is an ecocide. What you are seeing in the slide. What was our reaction for this? How can people react to an ecocide? This picture is very interesting, because people in Murcia changed the mentality. Murcia is famous in Spain because we are very, very conservative persons, and very hard to understand that environment is very useful for us. Not useful, but important for us. But the Murcia people, the people in the schools, in the jails, on the street, they went out and said, we don't want the Mar Menor how it is. And we started a movement who was connected with the social movement before the ecocide. The ecocide started in 2000. So the protection of Mar Menor was from the 90s, and in the 2000, around the Mar Menor came many activities like farming, agro-farming, and livestock farming. It started at 2000 and year 2000. What was our reaction? Our reaction was went to a municipality to start a regional citizen legislative initiative. But this regional initiative went wrong. And then we started a new campaign without money, only passion. And we went to the parliament. That you can see Teresa Vicente, you can see me, and you can see the Ministry of Environment, Teresa Rivera, who came to us and say, I am with you. We had another big ecocide in August 2021. In August 2021, we had started the campaign, because the campaign was started in November 2021. No, 2020. In November 2020 started the campaign, and in August 2021, we had the half of the signatures, only the half. Then the Mar Menor expressed again its sound, not sound, but we could hear the Mar Menor again saying, please save me. No, don't save me, but I am so wrong, I am so ill that something must happen. We started the campaign around Spain, and this signature from Pedro Sanchez, which is the president of the government of Spain, but was taken in Valencia. Valencia is north from Murcia, and he had time. And this is a very important issue, very important symptom. So you can see us in Madrid when we came with more than 630,000 signatures. We took the signatures in the night, because Madrid is 5 hours far from Murcia. We didn't say anyone that we went with the signatures going to Madrid, because many people was frightened because it was in paper. We could not make electronic, and this is so sad, because all people could sign with electronic. Not all, but many people could do it electronic. But we needed to do in paper, because the law who allows citizens to propose a new law came from 1984. This is a special law in Spain, which is not in other countries, which enforce the public participation rights in our constitution. So in October 26, 2021, we brought the signatures to Madrid. On March 19th, Teresa came. I am the bodyguard of Teresa. So I was with Teresa in the parliament, in the Ecological Transition and Democratic Challenge Commission, when they started to invited Teresa to explain the reasons of the law. You can read the reasons of the law in the law, but they asked Teresa to explain to the commission. You can find the law in English in the page of the Cátedra de Derechos Humanos de la Universidad. I will send in the chat, because you can all see the law. April 2022, we have the more than 2/3 of the plenary. With you can see the results of this day. So we were so happy to have this green color in the parliament. This is the Congress. People came with us. People came to protect, not to protect, but to celebrate with us, with Teresa, with me, with other members of the promoting commission, to celebrate at the door of the Congress. You can see Congress, the Congreso de los Diputados. We went to New York also. It was a very beautiful visit to the UN headquarters in New York, and the mayor of Los Alcázares came with us to celebrate, to defend the position of the Mar Menor case, together with the secretary of the University of Murcia. Harmony with Nature program recognized from the very beginning our achievements in Spain, and this was the last report. When you can see, this is in Spanish, but you can find the report in English, and you can see how they have followed up the process. And this is the law. When I received the law on the 3rd of October, the 3rd of October was the day when Mar Menor became a person with rights. And I could not cry more than I cried at 3rd of October. So it was so important that our work, our public participation, our democratic view went to a positive law that we were really, really, really happy. For this reason, I want to say that is my last word, and maybe I have consumed the time. I want to say that this is a people's victory. This is a people's initiative. This is a people's public participation story. We use the Aarhus Convention to make the law effective, and we will continue using the Aarhus Convention to access to information, public participation in the committees they were created by the law, and in the access to justice, because the access to justice is very important. We have an actio popularis. That means that every person is entitled to go to court, to go to administration, and to defend the Mar Menor. I want to say only that the 26th of November, you are invited to a very important party at the Mar Menor in Los Alcázares, when you can join us and celebrate with us the victory of people, the victory of nature.
So thank you, Eduardo. It's very inspiring to hear the story of the Mar Menor. And let's hope this ripples out in many other places. We have some questions coming through, and I think Nati's already answering a few of them, but please keep them coming and we'll get to them towards the end. So I'd like to introduce our third speaker, Grant Wilson. He's an attorney and based in the US. He's been defending rights of nature and also writing new rights of nature laws, winning courtroom actions as well on behalf of nature. And he works for the Earth Law Center. And Grant's going to talk to us a little bit more about some of the cases he's been involved in or is aware of, and perhaps some of the issues that we're having to face in terms of, when you apply or you're working on a new area of law, and what are we coming up against as we progress with this this new concept. So over to you, Grant. Thank you.
Hi, thank you so much for having me here today. You heard a great introduction, so I won't say anything else there, but very excited to share with you some insights today, especially from a kind of legal nuanced perspective. I think the idea of the rights of nature is really exciting. And then, if this is a field that you enter, whether it's through a legal lens or an advocacy lens, there are so many legal nuances to consider, because when you add this whole sphere of rights into the legal system, you have to consider how that impacts so many different areas of law and government. And, it's our job as advocates or attorneys to understand some of those nuances and provide advice and to navigate them in a good way, and to learn from some of the case studies that we've had. So I'm going to share my screen here. Looks like that works. Okay, good. Just quickly about Earth Law Center. We advance Earth-centered laws, legal movements, and relationships. And this includes the rights of nature, but also a variety of other legal movements that put nature front and center and that are transformative and that challenge some of the preconceptions of our legal system that it should only represent human interests. We believe it should also represent nature's interests. And of course, that is what the rights of nature is all about. This is our textbook over there, by the way. Quick plug, if you're interested, we wrote a law school textbook about a lot of these ideas. Just quickly to start, I think it's really important to differentiate the rights of nature and other legal movements related to it from environmental law. And this is just a little chart doing that. So under environmental law, which is our traditional laws that you probably have in the UK, that we have in the United States, they're very common. The fundamental problem with them is that they treat humans and nature as being separate. And even worse than that, they treat nature as just being human property. In reality, we all know that humans are part of nature. We're not separate from it, and we're part of this interconnected web of life. And recognizing the rights of nature is really about acknowledging this reality through law. There's a couple other distinctions to make, I guess, to jump to the third one. Under our current legal system, you can only protect nature, future generations, and other voiceless entities if current generations of humans, people alive today, and only humans are harmed. If it's nature that's harmed without an impact to humans, if it's future generations that are harmed without an impact to humans living today, there is no recourse under the law. So ecocentric law tries to change this. Now, I thought I was pretty cool coming up with this chart. And then just yesterday, I saw this amazing, amazing graphic that I encourage everyone to check out. It came up from the IPBES. And, it really goes into even more nuance than I just did. If you look in the left-hand chart column there, it says anthropocentric, and that's what we're living in right now. We're in an anthropocentric society. And then you can move into what's called biocentric or ecocentric, I was talking about, and then even pluricentric. And just to go to the quick columns there, the current approach is about human prosperity and livelihood. If we're talking about living within nature, not just living from it, we're talking about belonging to nature and the health, our interconnected health with nature. If you're talking about living with, not just living in, but living with nature, all of a sudden you're talking about stewardship and responsibility. And finally, there's people who believe that they are part of a river or part of an ecosystem. There's no distinction whatsoever. And then what we're talking about is oneness and harmony with nature. So just to let you know, and here's the second part of that chart, just to let you know, there's all of these philosophical approaches to our own relationship with nature. Some believe that we're part of nature. Some believe that oneness with nature. And as lawyers, as legal professionals, how do we put this into our legal system? So I encourage you to check that out. Okay, so that's just a little introduction, ecocentrism versus environmental law. There's these different approaches to our relationship with nature, and really think about that and how it could impact the legal system. And then we want to talk about our hurdles and nuances with the rights of nature movement. And I just wanted to bring up a couple examples of where there's been challenges, where there's been nuances, and how we can learn from that. And if anyone enters this field as what I would call an earth lawyer, or as an advocate for the planet, doing rights of nature work, these are just some important lessons so that you can learn right now and avoid some possible pitfalls, or really inform the work you do with a deeper level of understanding. So let's just quickly go through these, and that will be that. Okay, a hurdle, preemption by national law. In the United States, there's this whole movement at the local community level to pass strong laws saying that nature has rights at the local level. And they did this to push back against things like fracking, industrial farming, gas and oil drilling, lack of climate change action, and so forth. And of course, once local towns passed these strong laws pushing against these industrial activities, there was litigation. Oil companies or agricultural interests suing towns that had passed rights of nature laws. And kind of the lesson learned here is that if you have a national or federal government that is hostile to the idea of the rights of nature, and they've created a whole legal system that says nature is property, we own nature, and if you have a permit to destroy nature, your property, you can do it. And we don't care what the local government says because we are the federal government, we're at a higher level of government, that's called preemption. That's something you have to be concerned about as a practitioner in this field.
Grant, can I interrupt?
Yes.
Could you just go back a couple of minutes because we lost you. You suddenly cut, not there, but the same slide you were on. It's not that one, the next one. And you were explaining it and then, no, keep going the other way,
Oh, this one.
towards the end, this one, that's it.
Oh,
So
I skipped forward.
you just cut out, you're talking about preemption. I'm not exactly how far you got when we cut, but we certainly hadn't got very far, I think, on that slide, but you just, your sound went and you froze for a little while there.
Oh, that's weird. Okay.
Yeah.
Quickly, the lesson here with preemption is that if you have a federal government that is hostile to the idea of the rights of nature, which has been the case in the United States, you need even more creative legal thinking to kind of get around that. Something you can do is really figure out how to give nature a voice in local government. And even if you can't do things like prohibiting oil drilling in your community or ending agricultural, industrial agricultural operations. There's a lot of stuff you can do locally, but you have to kind of sneak around some of these federal national frameworks that are hostile to the idea of the rights of nature. And when I say hostile, I mean that they believe that nature is human property that we can do whatever we want with. And that's kind of the basic premise of many legal systems. And you have to be creative to get around that until you can do what Ecuador did. What Panama, what Bolivia have done, which is national change recognizing the rights of nature. And I know there's in the UK, there are folks working on the rights of rivers in various areas, and they're going through the same thing now. How do we creatively recognize the rights of rivers in a way that's not going to just get shut down instantly because of hostile federal legal systems to the idea of nature having rights? Another issue to be concerned about or to pay attention to is liability for nature. So starting with New Zealand, some of these rights of nature laws are based in personhood. They say that nature is a person, and as a person, it has rights, powers, duties, and liabilities, because people have liabilities. If you use the word person to describe nature, and therefore it has rights, there's all this baggage that comes with personhood because there's been centuries of laws saying what a person does and what it can do and so forth. And even in India, there was a rights of rivers decision for the Atrato and Yamuna rivers, and they eventually appointed basically the state government in the state of Uttarakhand as parens patriae, which means basically a legal guardian of the river. And the state government was like, no, we don't want to be the legal guardian of the river. People are going to sue us. If they drown in the river, if there's a flood, they're going to sue us. We don't want liability for an ecosystem. And, I think the thing here to do as a lawyer is to say that, if nature does what it naturally does, rivers flow, rivers flood, forests burn, there's not a duty as a guardian of nature to prevent those things from happening, because those are all natural processes. And you really need to make sure that guardians of nature, where they're appointed, know that they're not going to be liable for natural processes. If a river flows, what duty is that violating? I would say there's no duty violated if a river flows. That's just water particles following gravity. And it's important for guardians to know this. And when you're doing legal drafting, it's important to include provisions to protect guardians from unnecessary liability. Number 3, and I'll go quick on these ones, indigenous rights of nature perspectives. A lot of rights of nature campaigns are indigenous led, indigenous informed. There's many similarities between the rights of nature and many indigenous belief systems, such as the understanding that nature is alive, that humans have a duty to protect nature, that we can serve as its guardians. These are all informed by indigenous understandings. But in some places, rights of nature is a tool, and this tool can be used or has been used where there's a desire for indigenous sovereignty, such as in New Zealand with the Maori people. And maybe the government wants to co-manage an ecosystem with the indigenous Maori people, as happened with the Wanganui River. But they do something that's short of granting them full sovereignty over a particular ecosystem or landscape. So in New Zealand, with the Wanganui River, with the national park, with the mountain, all of these things have been recognized as having some sort of personhood. And there is co-management between the Crown government and the Maori people under this kind of rights of nature paradigm. And I think the thing to know here is that it's not just about the rights of nature. It's rights of nature here is a political tool to figure out a way in which indigenous peoples and the Crown government can co-manage an area. Some people might say that sovereignty over that piece of land, the Wanganui River, a mountain, a national park, is the preferred approach. But it's another tool in the toolbox, and I think that's something important to know in some contexts. I'm going to skip forward. I just have a minute left, so I'm just going to talk about a couple other nuances. Sorry, there's a leaf blower right outside my office, so if you hear that, I apologize. I want to quickly mention who serves as guardians, and then I'm going to talk about education, and then I'll be done. I'll skip over 5 and 6. The guardianship of nature, who speaks for nature, is really, really important. And something to know here is that in different jurisdictions, they've had a different balance of whether local community members, indigenous peoples, frontline community serve as guardians, or if it's members of government who serve as guardians. And to me, that's kind of like, members of government, why would they serve as guardians? Because aren't we trying to break away from this government-led paradigm that has caused the destruction of nature in the first place? And we should have authentic people who can actually channel nature's voice, who serve as the guardians of nature. But in some places, again, it's a compromise. So in Colombia, for the Atrato River, they've created this guardianship body to speak for this river, and that's really cool. And it's half community members and it's half government. So, you know, it's kind of, the government was like, okay, let's do the rights of nature. Well, this is from a court decision, but we need to have half governmental representatives still. In New Zealand, with some of these rights of nature cases, you know, the Maori people don't have a majority vote on guardianship bodies, and that's unfortunate. With Mar-Menor, which we heard about, the local people have the majority vote. There's 13 members of this committee of representatives that serves as the voice of the Mar-Menor. 6 are to citizens, and 7 are for citizens, and 6 are for members of the administration. So that's awesome. That's such a big difference when the local authentic community members who can really, really channel nature as having a voice have a majority on guardianship body. I think it's best if it can be totally community-led, but it seems like we're moving in that direction, and Mar-Menor was an example of that. I'm out of time. The last thing I just want to say is that there's lots of education and training. There's universities in the UK, such as Sheffield and Essex, that have done rights of nature work. We wrote a law school textbook. There's about 4 or 5 other books on the rights of nature. So if you're interested, if you're a lawyer, if you're an advocate, whoever you are, there's lots of stuff out there to dive deeply into the subject matter. Sorry again about the voice delay. If you did hear a leaf blower out there right outside my office, I apologize if you didn't hear it. Zoom is amazing, so thank you to Zoom technology team, and I appreciate your attention.
Brilliant, thank you, Grant. I think it might have been only me that lost you. I think other people could still hear you. So we move to our final speaker, Zoe. She's with us. I can't see her on my screen just now. Here we go. Here she is. Hello, Zoe. So I'll just introduce Zoe briefly. I've known Zoe for quite a while. We started out together working on ecocide issues, and more, I guess, the last 8 years or so, working together on and off around rights of nature issues and through Earth Thrive, Zoe's NGO. And she's going to talk to us about some of the cases that she's been involved in or has thoughts on, and different movements that are happening in Europe around rights of nature. So over to you, Zoe.
Many thanks, Lisa. Yes, it's well over 8 years. It's about 12 years now, I'm happy to say. And I'm really glad that you're my dear friend above all. And thank you for inviting me to this really amazing webinar with other friends of mine, because we in Rights of Nature movement see each other as friends and actually family. And we just had a most beautiful gathering in Siena last month. And on the last day, there was so much crying. People didn't want to go home because it was so beautiful. So it's more than friends. It's literally like family. So thank you to everybody. I have to say, it's thanks to Rights of Nature that I'm keeping optimistic when it comes to protecting our planet, because this is the solution to, together with permaculture and law of ecocide as the other sides of the same coin. I really see this as a solution, and I'm so happy that the movement is growing so quickly, especially in my beloved Europe. Fidan, before I start talking about various, well, just really running through the huge list of initiatives in Europe, can you please just show the map that I sent you earlier?
Yes,
the link to
now.
the map.
Yes,
Yes,
now.
please, so that people can see the map rather than me.
Okay, is it okay?
That's the one. There should be a lot of dots on it showing though.
Yes. Oh, this one?
No, not that one, the previous one, but there should be a lot of dots showing the cases in Europe, this one.
Okay, let me just cases.
I think so. So I'm going to run you through the rich tapestry of rights of nature initiatives in Europe. While on the one hand, Europe is unfortunately experiencing an unprecedented attack of extractivist projects all over Europe, from North Scandinavia, which is seen and portrays itself as green, but it's actually not, all the way down to the south, which is now becoming quickly neo-colonialized like Africa was in the previous century. But at the same time, while we have this attack from corporations and governments, are working together in tandem and giving them all these licenses for huge mines, for burning down forests and all sorts of stuff, we at the same time are seeing a rapidly growing movement that stands up to that and opposes it on the basis of the right to life of all living beings. So even though Europe came to the rights of nature movement somewhat late, well, in comparison to Latin America in any case, I'm happy to say that rights of nature in Europe movement is a thriving one, and it's a fast spreading movement with a growing number of local and regional initiatives all over the continent. So our members and allies come from more than a dozen countries around Europe, and they come from very biodiverse regions. And currently there are numerous initiatives for the establishment of some level of the recognition of rights for just about every ecosystem in Europe, from rivers, lakes, glaciers, forests, to the amazing pioneering initiative on the rights of peatlands, which I find amazing. And there was a conference recently on the subject, and I would encourage everybody to look it up. There is also a fantastic initiative on the rights of wetlands, which is global, but it started off in Europe. So some of the initiatives around Europe, starting from north, we have in Sweden, Lake Wattern, which is fighting a triple ecocide, and Lake Wattern is the second largest lake in Sweden, and it's the main source of drinking water for people in Sweden, but they're fighting a huge mine, a paper factory, and army is using it as an exercise ground, polluting it with all sorts of ammunition and whatever pollutants the army releases. The community has been gathering around around the lake, and they've already held 2 rights of nature tribunals, one the local one, and they participated in Global Alliance for the Rights of Nature European Hub Tribunal for the Rights of the Aquatic Ecosystems last year, and they were one of the cases that we presented. Then going further down, we have Ireland, and the rights of nature is rapidly growing there as a movement. It first started around the opposition to a gold mine, but now I see it really exploding, if that's the right word to use in the circumstance, with all sorts of initiatives, and it's galvanizing itself as a serious movement there. Going further down yet, we have Netherlands with 3 really major projects there. There is the right of the Waddenzee or Waddenzee. It's a tidal wetland that people are looking to protect by recognizing that it can own itself. So nature owns itself, people don't own it, and will on the basis of that try and save the Waddenzee. There is the Embassy of the North Sea. The project is run by some of the foremost advocates of rights of nature. They even have PhD on the subjects, which I find fascinating, and would like to see that all over Europe, people being able to study on the subject, which is something that's happening in Italy, but I'll mention that later. And then there is also the rights of the river Maas, and it's mostly centered around cleaning the pollution of the river Maas. Then further down in the UK, there's a surprising number of initiatives happening there. Last year, for example, there was a ceremony that took place for the rights of a river Wye. From town council tried to pass a bylaw that would give a section of the river from legal personhood. That's really not gone completely all the way through, but the initiative still stands, and it's, you know, people are working on it. Further down south in the UK, in Devon, we have charter for the River Dart. Now, that's not exactly full-on rights of nature initiative at the moment, as Isabel, who runs the initiative, thought that it might be slightly advanced for the local community. So they're just starting with a charter with a view to having full rights in the future. And that is something that in certain communities which are not really yet at that level, maybe of consciousness or organization, might be one way to start off, rather than going, you know, a full-on rights of nature language that we maybe in the movement would use, because then you might lose some people. So, you know, a gentle approach could work as well. Then there is also, I think Grant mentioned, the Lawyers for Nature organization in the UK, who are working very hard on the rights of trees. And now Paul Powelsland, who's the director of the Lawyers for Nature organization, he is working on climate justice too at some kind of national level forum, as I understand, which is really major for the UK, given the level of all sorts of environmental laws going backwards and all sorts of rights going backwards. To see rights of nature actually advancing, I think is fantastic. It's very hope-giving. Then in Germany, we have an incredible member there called Hans Leo, with a whole list of fantastic projects running under the German Rights of Nature initiative, which I encourage you all to take a look at, because the way he's organizing the communities there is very interesting. Even Switzerland has an initiative to protect rights of nature in their constitution. I don't have really that many details about that, but I have heard of that, and I find that fascinating, because I don't know of any individual organizations working on it over there. Then moving further south, we have France, and France is a real hotspot of numerous rights of nature initiatives in Europe. There is a declaration of the rights for River Tavignano in Corsica, and pretty much all of Corsica is, you know, talking about some kind of rights of nature for the island. We have a really good project called Appel du Rhône, Parlement du Loire. There is rights for the River Seine. There is rights for the glacier Mar de Glace, which was one of the cases from our tribunal last year. There is the case of Red Mar, the ecocide near Marseille, and that was yet another case at our tribunal. And there are various other cases. I'm not going to number them now, but if you are interested in French initiatives, we do have within our European hub a Réseau Francophone, which is a specifically French network. that you might like to look up and join. And there is quite a lot to learn from them because the initiatives are so varied and done at different level of development, but also done in different way. As you can see in Europe, each initiative has their own way of developing and the way it's been structured, obviously, in relation to the local circumstances. Now, Italy is rather interesting because I don't know of any actual ecosystem initiative, right, for an ecosystem initiative in Italy. However, there are a lot of academic and institutional initiatives happening there. So I remember maybe 2 years ago, there was a course, a short course, or was it like a semester course on rights of nature at the University of Bologna. And I know at the University of Siena, there are several professors there who are actually very active in the field of rights of nature. And I think they also teach it at some level and some, you know, some courses. Again, it's not a proper university course, but it's a very, very good start. And it's especially interesting for the University of Bologna because it's the oldest university in Europe. So that's a very interesting development to see. And we hope to be able to maybe develop some more academic discourse with them and some material for people at other universities. That brings me down to my native Balkans, and it's pretty much my organization that is running things over there or trying to establish. We are working on the establishment of the Center for the Rights of Nature, Balkan Center for the Rights of Nature, where we are hoping to connect all the Balkan countries, especially Western Balkan countries, and to bring them on board because we all suffer pretty much the same problems, the same mentality, the same kind of government, and we are all desperate for real, true solutions. So what are we doing there? Well, rights of the Balkan rivers was one of the cases at last year's tribunal for the rights of the aquatic ecosystems. And following on the verdict that we got from our judges, we are now preparing a restorative justice proposal for our government and for the investors in the dams, which were the subject of our case. We are working with the European Forum on Restorative Justice on this project, and they are really donating their time and their expertise because it's a pioneering thing for them as well. So it's a very pioneering thing for the entire Balkans, and there are a lot of interesting people there, not just the community from the actual tribunal, but also some other communities who have heard of this and would like to free their rivers from the dams, most of which have been built there illegally. So we are looking into ways how we can do that. So as a part of our restorative justice process, we would also like to offer to our communities the actual law for rights of rivers. So what we are doing now, together with International Rivers Earth Law Center grant and a local lawyer, we are currently transposing the rights of the rivers law declaration really into the Serbian legal system. So once we hopefully manage to start the process of restorative justice, one of the things that we would like to present or offer will be the rights of rivers in the Serbian legislative system, which we are aware will not happen anytime soon, given the circumstances in our country, the very corrupt government. But what we can do is at least symbolically have it locally pronounced. And there is indication that maybe at least one of the local municipalities might be able to get on board with this and at least have it in some ways enforced, which would be a huge legal precedent. Speaking of which, and as mentioned earlier, we are inundated with extractivist projects, and especially in Serbia, which is unfortunately very rich in various metals and minerals. And our government has issued at this moment around 27 exploration licenses for mines. Now, for a small country like ours, that means we would end up like a Swiss cheese with all the holes around the country. So because there is a very little recourse to justice in the Serbian system, what we have done together again with Earth Law Center, but also with King's College Legal Clinic for Human Rights to Healthy Environment, we have sent off no less than 3 complaints, international complaints, to the Berne Convention, which is conserving flora, fauna, and wild habitats of Europe and some of the countries in Africa. But what we did is we used the first point of the preamble of the convention, which says that nature has an intrinsic value. And from that, we developed a very good, very strong argument to argue against these mines on the basis of rights of nature, because that's what the inherent value is. And to our delight, all these complaints were accepted as valid. Therefore, our argument on the basis of rights of nature against the mines was accepted as valid. And that, as far as we know, is a precedent, is the first one, for such a international complaint, legally binding complaint. And that makes us really happy. So again, thank you, Grant, for your amazing help on this. But we are also learning a lot from the Ecuador examples, because some of the corporations that are trying to dig in Ecuador, like Dundee and their gold mine, are also trying to open a gold mine in Serbia, and that is one of the subjects of one of the complaints. But we are also now working and communicating with communities in Ecuador to learn from them, and see how we can help each other, and share our knowledge and experience. And that's definitely something that I would advise everybody, who's interested in rights of nature and starting an initiative to learn from others, because there are various ways on how these things can be set up. And sometimes you won't think of something, but somebody's already done it. And it's really good for everybody to communicate. Another huge project that we are working on, and that's really, really huge long-term project, huge in terms of the size of the area, but also in time scale, is the Mediterranean Bioregion Declaration, which it's a project that is attracting a lot of interest, and which we are starting off on the voluntary basis. So we are inviting everybody who's working on some kind of rights of nature initiative in the Mediterranean bioregion to join and sign the declaration, and then voluntarily implement rights of nature on the ground, while at the same time working upwards to get their governments to eventually sign up to that, so we can get the declaration to become legally binding, just like the Berne Convention is. But more than that, these conventions are not really very much enforceable and can be a piece of paper sometimes. What we want to do is to really instill rights of nature thinking, but also living on the ground in the whole of the region. And we are speaking with various communities on the ground on how best we can do that. And there are various ways through workshops, through various courses on the legal aspect of that, but also on introducing permaculture, because permaculture for us is how you live rights of nature on the ground, how you live in harmony with nature. So then you're really in compliance, not just with the law, but with the actual ethics of it. So that would be some of the initiatives that are happening in Europe. But I'd finally like to mention our hub, our Global Alliance for the Rights of Nature European Hub, that all of these amazing projects are under. And that's our big family that was founded in 2019. And it's been going from strength to strength. And I would invite you all to join us. I'm going to post the link to our website in the chat. Let me see, to everyone. I would encourage you all to check our website, to send us an email, to ask any questions, if you need any help, or if you need an advice, or if you'd like to join any of these numerous initiatives that I've mentioned. And that's only about the half of what's really happening in Europe. Please do. We have also within GARN, we have a legal hub, we have an academic hub, we have really phenomenal youth hub, very active. We have numerous hubs, everything for everybody's taste, everybody's initiative, everybody's circumstances. So please do join us. And ask any questions. Thank you.
Thank you so much, Zoe. That was a really excellent overview and just shows you what's emerging and already happening. And that's just in Europe. Of course, in other continents, things are also going on. But I just wanted to do a little round up a few of the thoughts that have come through so far, and then I'd like to go to the chat. We've had a few questions already that Natty's answered, but I'd like to open those up to the other speakers in case they have some thoughts on those questions. And then I will scroll down and see what else is coming through. So I think it's clear what we have in rights of nature is it's incredibly promising, but clearly it's not a quick fix. And as we see, it's underpinned by a philosophical approach that is clashing with other worldviews about the rights that humans have to extract and exploit, and actually just to keep our current way of life going, which of course everybody is running around trying to figure out how do we keep doing what we're doing and address climate change, and not have a huge impact on biodiversity while we're doing it. These are the big questions of our time. I thought it was in a way quite funny when Grant said, oh, I have a leaf blower going outside my window, because do we really need leaf blowers? I mean, for goodness sake, using electricity to push leaves around is insane. And we can think of many arguments of things that we've come up with that perhaps at time of climate change, really, do we need these things? Anyway, just one good example there. And Grant, you also talked about how it's good that the more we can keep these cases at the community level so that communities are able to decide for themselves. And I mean, we already see the tension in many countries between the rights of communities to self-determine and maybe the national government saying that they don't, they override it because they say, oh, well, we think this development is good for jobs or, good for the national whatever, but the local community is saying they don't want it and it gets overridden. And obviously that's happening a lot in the US as well. We've certainly seen that in the UK in different situations. Zoe, you mentioned the Berne Convention and this being this intrinsic value argument being accepted. And again, I think the way that we are seeing language used in courts and in many different areas of law and policy, there is this movement in our consciousness happening around ecosystems, which is natural because, of course, we see so clearly how much impact and devastating impact we have. So in a way, it's not surprising that finally we're getting it, but obviously we need to do it a lot faster than we're doing. But the last point I wanted to make was also about the restorative justice point, because I think this is really important, because if you think about the punitive legal systems that we have at the moment, it's not at all holistic. And one of the aims of rights of nature is actually to be able to bring parties together so they can see each other properly and fully and actually explore, how it is for each other to either be a perpetrator or a victim of the harm. And I think that's one of the most powerful things in a way for humans about the rights of nature, is that it also enables, ideally, for there to be a sort of a holistic outcome for all parties to understand each other and hopefully move on, move away from the harm or to figure out a way how we're going to restore the harm that we've already done. So I would like to go back to the questions, and Natty kindly, she's already answered a few, but they're such good questions. I thought the first one, and I'm sorry if I'm going to pronounce your name really wrong, but it looks like Jacquan or Zakan to me, has asked, I would like to ask a question. Could you give the definition of integral health in Article 1, which is a really great question. And I wanted to answer or give Natty's answer, because I think this is really important. Again, it's coming to the heart of what we're talking about here, the right to integral health. It's interesting because, and these are Natty's words, it refers to the health of nature, of the environment, not only the health of human beings, but the integral health of nature, restoring the health of nature that is being destroyed by pollution and extraction. Recovering and restoring Earth's health and balance is the main focus of the rights of nature, not to isolate nature in protected areas, but to restore our relationship with nature that is now sick. And if nature is sick, we are also sick, of course, and we are not separate. And of course, we see this also in constitutions from a more anthropocentric viewpoint, the human right to a healthy environment, which we will also be talking about in a future webinar, and how this is coming through in a different way, but a more anthropocentric way. So the questions we had, where is it? Franz, again, I'm going to say this name wrong, I'm sure. Francisek, who asked first, so about introduction of rights of nature is not stopping or decreasing the level of oil extraction, quite the opposite. The level has grown since 2008, and the government uses the concept of buen vivir, or good living, to justify the extraction. What's the opinion on this subject? Moreover, governments, businesses are able to take care of human rights. Human rights are not able to stop human rights abuses. So the question is, are rights of nature radical enough? So I would ask, I know Natty's already answered that. If you want to say more, Natty, feel free. Maybe Grant or Zoe or Eduardo would like to comment on that. Are rights of nature radical enough in light of the fact that it's, we're not at the moment able to stop extractivism in Ecuador, which already has it in the constitution?
Well, personally, I can't think of anything more radical. What is more radical than respecting the right to life? I mean, what is more important than life itself? There is no excuses. There is no, I mean, going back to the Berne Convention, the preamble has 10 points. The first one, yes, is inherent value and why we should protect, flora, fauna, and wild habitats. But then there is the recreational value, the aesthetic value, the economic value, and what's not. We completely disregarded those and just went for the only thing that really matters, life. End of. I'm sorry, I don't know who asked that question, and I understand where you come from. But what is more radical than that? I just can't see it any other way. Who in their right mind can say that they're against, protecting life? I just maybe that's because that's my standpoint. So I can't really see other people saying, oh, well, no, life is not really, worth protecting. But for me, that is the most radical movement there is. The only thing is that we need to be even more massive than we are. But going back to what I mentioned in Europe, and Europe is an old continent with really well-established corporations, and we have kingdoms and governments like really entrenched. It's not a young continent with a lot of movement, but I see on the ground so many things happening, even in my own Serbia, where people are very conservative, and really, when you say green, they think grass. The environmental field is not really that developed, but they are understanding rights of nature. They are understanding protecting actual life, and I've seen that on the example of rivers, and giving personhood to rivers. So yeah, that's just my take. But then I'm environmentalist. I'm not a lawyer, so maybe a lawyer will have a different reply.
Thanks. So yeah, I had a couple of quick thoughts just to kind of mash together that question and the last one about integral health. By the way, the leaf blower is back there. Whenever I'm about to speak, they turn it on and stand outside of my office and start blasting the leaves. It's some sort of sick joke, but I'll try to focus. So yeah, I totally agree with what Natty said on integral health as a term. It's not specifically defined in the Constitution, and so we're kind of looking at some of the case law to see what it means. In the Los Cedros case, the court was really looking at the health, not just of Los Cedros protected forest, but of surrounding ecosystems, and how would mining operations in Los Cedros protected forest impact surrounding ecosystems. And I think that's an important clue as to what integral health means, which is that we're not looking at one river, one forest, or one mountain in isolation. It's about this larger system of which this is just one part. And I think, you can look into the word health, and we've done research into what ecosystem health means, what river health means, what ocean health means. And traditionally, when governments or policymakers define these terms, they're often from a perspective of maximum sustainable yield. How much can we take from the ecosystem without it totally collapsing? So ocean health, oftentimes that's defined from this perspective of, how much can we exploit before the fish stocks, which is the term we use to describe all the fish populations. We call them stocks because they're property. How much can we take until they collapse? And that's what ocean health is about, oftentimes in policy making. But I think integral health in Ecuador, despite it being undefined, as applied, is about looking at the intrinsic health of the ecosystems themselves, and it takes this larger perspective of surrounding ecosystems and the whole web of life. So that's kind of some of the ways I see it as being distinct from what health looks like in other contexts. And then, obviously oil extraction is happening. It's gotten worse in many places. A couple of comments on that. One is that Ecuador's rights of nature decisions were very inconsistent until recently, when I think the Constitutional Court has made some clear statements about what it means. And I think this could maybe change things, although the political dynamics always are shifting in Ecuador as with other countries, and sometimes you take 2 steps forward and 1 step back. In the Los Cedros case, again, because it's just a really interesting case, what they're looking at, in addition to the rights of nature, is the precautionary principle. And it's as much a rights of nature case as it is a landmark case on the precautionary principle. And what the courts basically said is that, before you gave these mining concessions in Los Cedros protected forest, you didn't do this, you didn't understand the impacts to this larger ecosystem. And either you didn't understand them or we were incapable of understanding them. And either way, we're going to cancel these permits. There might be cases where they totally understand the impacts and they decide it's, isolated harm and it doesn't violate the rights of nature. That's possible. I kind of see the rights of nature as a tool, at least in the short term, to prevent the worst actions, the worst atrocities against ecosystems. The really clear-cut examples were the rights violation, and that was Los Cedros for sure. And in the longer term, again, to get to the question of, is it radical enough? I think I agree with Zoe. I think yes, but I think it has to be integrated into all levels of our legal system to achieve that radical impact in practice. So maybe before you engage in an extractive practice, you have to do a whole scoping document that analyzes the rights of nature. You have to get a rights of nature permit. That would be an example of bringing this further into the legal system. Or maybe science has to be more informed by indigenous perspectives that align with the rights of nature and so forth. So I think yes in principle, but you have to make it so radical in practice.
Thank you, Grant. I don't know if Eduardo was wanting to add anything on that point, but
on the point of restorative justice, or
no, we moved on a little bit. I was looking at actually, it's fine. I think we had a good answer from Grant and Zoe already, and I'm just aware of the time. So I will move on where, if I can find, I'm just scrolling through here. Yeah. One thing I wanted to point out, if people are looking at the chat, Grant has mentioned that the Earth Law Center have a course that they're running. Grant, do you want to say something about that? Because I'm just trying to find it. A course on ecocentric law. Do you want to mention that?
It's our third summer doing it. It's normally just about 4 hours a week plus some reading the 2-hour classes on last summer is Monday and Wednesday in a time zone that works for both Europe and North and Latin America and other places, we hope. It's been free in the past, and I believe it'll be free again this summer, at least for students or those sorts of folks. We charge for law firms and governmental representatives and those sorts of folks, but we're pretty flexible. So yeah, check it out. Send me an email. It'll start in July 2023. Tony Zell, tzell@earthlaw.org is running the course, and you can email him if you have more questions. And we're always, we also integrate projects into the class, a kind of practicum element, so you get some experience doing some real world rights of nature projects. And yeah.
And that may be a good place for Seville to start. She has asked, I want to specialize in environmental and in brackets ecocentric law. What can you suggest for beginning internationally in this sphere? Well, I would suggest diving into a project, maybe one, I don't know where you're based, Seville, but perhaps one of the projects that Zoe's mentioned that are actually active and ongoing at the moment. Eduardo, would you like to say, as an environmental lawyer who's become more of an ecocentric lawyer, would you like to answer that question?
I only answer with a story of myself. I was anthropocentric, and when I first knew the idea of ecocentric approach for law, I had my doubts. It was Muntaito from England, from UK, who advised me take the ecocentric way, like the wild side, take the ecocentric side. And I was not convinced from the very beginning. But now I am defending rights of nature because I have realized that we are part of the ecosystem. We are not humans separate from ecosystem, and the law must answer to this question. The law cannot be anthropocentric anymore because we are driving into a collapse moment. I mean, if you ask me how can you start with an ecocentric law, I will suggest you to know the judgment of Atrato River. The judgment of Atrato River is a very good point, a start point to understand the both approaches. And I invite you to know more about Mar Menor case or Mar Menor Act, because it's the first ecocentric law in Europe. And we have made with many passion and love.
And thanks, Eduardo. Nati has raised her hand as well.
Thank you, Lisa. And just to answer to that last question from Francis, and to wrap up also with what you were asking earlier of this idea of like a compartment of dividing up nature, because now we have ecosystems that are getting rights, but not like countries. Unfortunately, Ecuador is still the only country that has rights of nature in its constitution. We're hoping that Chile will follow, but I think that Chile wasn't ready to make that big change yet. But of course, having rights of nature in the whole country is the ideal. However, even in Ecuador, we have judgments of the Constitutional Court ratifying, for example, the rights to mangroves. So I think that we are risking that we are just like giving again, rights to specific ecosystems, but it is a way forward. I don't think I'll ever criticize any movement that is trying to protect the rights of a river or an ecosystem. Of course, what we're all aiming is to have rights for all of nature. Actually, that includes us, because we are nature, so that we actually break that limit of like human rights and rights of nature, and that we all become that. But it's hard to change mentality. And I think that we start looking at this, then little by little we'll add up enough that will make this shift. So definitely start and keep on promoting rights of nature. And of course, where we see ecocides and where we see these like big, kills like what we saw in Mar Menor, it's easier because you can see the urgency and you can see the ecosystem dying, but the planet is dying. And now we have our authorities talking about, what to do with the climate, and they're not taking any action. And I think that rights of nature is very interesting because it empowers people to say, okay, you guys are not doing your job. We are going to do it, and we're going to get organized to give rights to our river, to our forest, to our ecosystem. And that's quite interesting. And I'm just saying, and I understand the frustration about, the problem is the system, the problem is capitalism, the problem is the use of nature and destruction of nature. And what rights of nature really is that, of course, we're trying to promote it in legal systems, but that's not enough, and that it doesn't stop there. What we're trying to do is change people's mentality that we are part of nature and that we need to change our relationship with nature. And once we do that, then the change comes. And that's a much faster way than just protecting the environment with the environmental law that we've seen is completely useful to this capitalist system. So that's why I support the rights perspective. And yes, let's try to make this movement even bigger, so we don't do this as an acupuncture, but we actually do it for the whole the whole planet. But it's definitely a growing movement that is not mainstream yet, but it's getting there. It's growing very fast. So I just wanted to take advantage and thank you, Lisa, and the magazine for Consensus Law for bringing us all here, because it's important to raise the voice and to come together with this idea.
Thanks, Natty. I think that's a good place probably to wind up, although I'd quite like to keep going. I don't want to respect everybody's time, and I know Eduardo has to teach soon. Let me see. I'm just looking at what's going through here. We have some answers and questions. Francisek, I'm simply making the point, even human rights don't change a relation of power. Yeah. 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 So yeah, as a lawyer, I fear that both human rights and nature's rights cannot stop capitalism from destroying the planet. This is the big question. I think I would like to end. I come back always to a quote by an indigenous elder called Casey Camp Horinek, who's she's an indigenous elder of the Ponca tribe of Oklahoma. And she said once, we are not humans defending nature. We are nature defending itself. And I remember reading that. We are not humans defending nature. We are nature defending itself. And for me, that encapsulates exactly what we're doing here with this work. And I wish everybody well with it. I hope people who've joined today, thank you for being here. And I hope it's inspired you to find out more and to follow some of the links in the chat that have been posted there. Maybe you have a few minutes more to take them down. I know the Mar Menor case, there's a link there to an English translation. And yeah, I want to thank the speakers for their time and really interesting presentations. And again, to Consensus, to Fidan at Consensus, and Hussein, I was also here from Consensus Law for hosting this. And in a couple of weeks, we will have a second webinar on the law of ecocide. We'll be posting information about that soon. And I think it will be Jojo Mehta who will be our key speaker, as well as some other panelists. And I'm looking forward to that. So thank you again, everyone, and stay well, and see you soon. Thanks, Fidan.
Thank you.
Bye-bye, everyone.
Thank you. Bye-bye.
Thank you. Bye-bye.
Bye, Zoe.